Welcome to the Legal Art Podcast. I'm your host, Michael McCullough. I was speaking at the Art Law Day conference in the fall of last year, and I was asked a question about a lawsuit filed by the Cleveland Museum of Art against the District Attorney of New York. And I didn't have a time to answer that question because I was busy talking about other cases that I'm working on. But I thought I'd take this podcast to discuss the case because it's really interesting. So in October of last year, the Cleveland Museum of Art filed a complaint against the District Attorney of New York County, which is known as DANY, the DA of New York, D-A-N-Y. The lawsuit was filed in the Federal District Court in the Northern District of Ohio, and the museum is seeking a declaratory judgment naming the museum the owner of a second-century bronze sculpture of a man known within the museum as the Philosopher. So let's take a look at an image of the work. So this is an over life-size Roman bronze of a man, a Roman man, and most probably an important Roman person, dressed as a Greek philosopher. And we know this because the garb the man is wearing is a Greek philosopher's tunic, and the sandals are Greek sandals. So this is a Roman, an important Roman person dressed as a Greek philosopher. Now, it's 6'5" tall without the head. It would be over 7 feet with the head. And it is a very impressive sculpture. If you've ever been to the Cleveland Museum and have seen the piece, it's an amazing sculpture. It's exquisitely cast. It's well preserved, and it's one of the best Roman sculptures that is on display anywhere. So how did the dispute come about? In August of last year, DANY applied for a search warrant in the New York Supreme Court, alleging the Philosopher is a statue of Marcus Aurelius, looted from an area in Turkey known in ancient times as Bubon, which was a city of ancient Lycia in southwestern Turkey. So according to DANY, this is a statue of the Emperor Marcus Aurelius. Now, DANY believes the Philosopher is stolen under the Turkish patrimony law of 1906 and must be turned over to DANY for repatriation to Turkey. And in order to persuade the museum's leadership that the Philosopher is a likeness of Marcus Aurelius that was looted from Turkey, DANY obtained a court order allowing it to share its evidence underlying the search warrant application with the museum. And after the museum's review, the museum said that the evidence DANY offered of the Philosopher's theft is insufficient and inconsistent. The museum responded by suggesting ways of obtaining better evidence to rectify DANY's claims, and not surprisingly, DANY refused the suggestions. Thus, the museum remains unpersuaded that the Philosopher is stolen from Turkey, yet DANY believes it is stolen from Turkey. So the question that arises is, what do we know about the object? So I'd like to show you an extract from the Cleveland Museum's website. So this is an extract taken from the Cleveland Museum website on October 18th of last year. There is the Philosopher. It's called a draped male figure, Roman or possibly Greek Hellenistic, although it's certainly Roman. And if we scroll down, here's the known provenance for the piece. So it says, Mr. and Mrs. Charles Lipson, Boston, Massachusetts. No date and no information about where Lipson acquired the piece. Then 1986 consigned to Edward Merrin Gallery, and then sold by Merrin Gallery to the Cleveland Museum of Art in 1986. So it goes Lipson, consigned to Merrin, sold to the Cleveland Museum of Art, but no information about when and where Lipson acquired the object. However, if we scroll down to the exhibition history, we get a better sense of how long the piece has been around. So Lipson loaned the piece to the Museum of Fine Arts in Boston in 1967, and it stays on exhibition for 3 years there. It then goes to the Indianapolis Museum of Art in 1971 for another 3-year stint there. It takes a couple of years off, and it goes to the Minneapolis Institute of Arts from 1976 to 1980. It then takes a short stint at Rutgers in New Jersey in the fall of 1981, then goes off exhibition, and then is purchased by the Cleveland Museum of Art, where it's exhibited from 86 just until last year. So that's a pretty good exhibition history. All but 6 of the last 56 years have seen the object on view at a major museum. Now, there is also a publication history here that we can look at quickly. So there are a couple of early publications when the Museum of Fine Arts Boston first shows the object in the late 60s. So they look like one of them at least is a German publication, it looks like. Then the Indianapolis Museum publishes it a couple of times. Then looks like there are a couple of Turkish publications in the late 70s, 77, 78, 79. Then looks like a Swiss publication article on bronze portraits. Rutgers then publishes the object in a museum catalog when it's on exhibition in the fall of 81. There's an Indian publication in 82. And then there are a string of articles that are really part of one publication, the Bulletin of the Cleveland Museum of Art in 1987. So after the 86 acquisition, there are a number of articles published on this very important object that the museum acquired. So that's really part of one publication. We then have a 1989 American Journal of Archaeology article, Archaeology in Anatolia. Then another Cleveland Museum 91 publication, another Cleveland Museum 91 publication, Cleveland Museum again in 92. Harvard University Arts Museum article in 1996. Another Cleveland Museum article in 2001. Looks like a book from University of Toronto Press about Roman dress and fabrics in 2008. Another Cleveland Museum article in 2012. Then we have Dr. Elizabeth Marlowe publishing in 2013, Shaky Ground, Context, Connoisseurship, and History of Roman Art. Looks like a critical publication, 2013. A couple more Cleveland Museum publications. And then we have a couple more articles in the teens, one of which looks sort of critical, the one by Patrick Howlett Martin, Art, Nationalism, and Cultural Heritage. Artworks belong where they are found. That was in 2017. So a very good exhibition history, a decent publication history. There's some early publications, a lot of museum publication, though, for the exhibitions, and maybe a couple articles in the teens, but a pretty thin provenance. So that's the information from the museum's website. And to sum up, the date of Lipson's acquisition seems to be unknown, but Lipson exhibited the Philosopher pretty widely before the museum's acquisition. And then, the Philosopher also appears in the other museums and in some publications in academic literature, including what it looks like a couple of articles in Turkey or by Turkish writers. So I think the question is there any more information out there about the piece? Because we don't have access to the search warrant application. And in the museum's complaint, there's not a lot of information about where Lipson got the piece. So I did some research and I found an article by Dr. Elizabeth Marlowe. And according to Dr. Elizabeth Marlowe, who's an associate professor of ancient and medieval art and museum studies at Colgate, the story of the looting at Bourbon is well known. And Dr. Marlowe published an article entitled, "When Will Museums Tell the Whole Truth About Their Antiquities?" And it was published in Hyperallergic, where she claims that in May 1967, two brothers discovered at least 9 life-size bronze statues and some fragments in southwest Turkey, known in ancient times as Bourbon. According to Dr. Marlowe, these bronzes were excavated and sold to a dealer in Izmir, who then smuggled them out of the country. A few weeks later, 4 headless male bronzes, 3 nude and 1 wearing a philosopher's tunic, all about the height of 6'5", appeared in the possession of Charles Lipson, a Boston art collector who began showing them to museums. Interesting. So Dr. Marlowe is not surprisingly critical in this article of the museum's acquisition of the Philosopher, and she points to the fact that in 1986, when the museum purchased the Philosopher, and I'm quoting now, "The press release and subsequent publications stated openly that it was part of a group of Roman bronze figures and heads believed to have come from Turkey that represent various emperors and empresses created for a temple of the imperial cult in the mid-2nd century. Likewise, when 6 of the pieces were featured in 1997 touring exhibition of classical bronzes, the catalog stated that they were, and quote, subquote here, reported to be from Ipsic ancient Bourbon, close quote. So according to Dr. Marlowe, this is a known site that was looted by two brothers who then sold the pieces to a dealer who smuggled them out of Turkey and sold them to Lipson. Now, what does the complaint say? So according to the complaint, the museum consulted experts who have doubts about the identification of the philosopher as Marcus Aurelius, and currently believe that it's much more likely that the headless figure is a depiction of a Greek philosopher based on the robes the figure is wearing and the dissimilarities to other statues of Marcus Aurelius. Those experts also cast substantial doubt on the notion that the philosopher was ever in Bourbon or in modern-day Turkey. However, if you go to the museum's website hosts a video that I'd like to show you.
For Romans, they really conceived of a full body portrait statue in two separate parts. So you had the body and you had the head. Often the head was made separately and then attached to the body. And so many of the heads that you see behind it when you are in the gallery would originally have been inserted into full body portrait statues. And that's the case with our bronze portrait statue here as well. It's impossible to know for sure who this statue depicts. We know that it's a person of great status for several reasons.
It's enormous. It's over life size. And the quality of the execution of the piece is remarkable. So this was done by a famous artist, and the subject would be someone extremely important, and the most important person at that time would be the emperor. So it's considered to be an imperial subject, an emperor, dressed as a philosopher.
And if that's the case, the most likely candidate here is the Emperor Marcus Aurelius, who ruled from 161 to 180 of the Common Era. And he was a noted student and enthusiast of Greek philosophy. And if there was going to be a Roman emperor who was going to be shown as a philosopher in the Greek-speaking East, it almost certainly would have been Marcus Aurelius.
So that's interesting. According to Maggie Popkin, who is an assistant professor of Roman art at Case Western Reserve University, the object is, let me quote what Ms. Popkin says. I'm quoting now. It's impossible to know for sure who this statue depicts. The most likely candidate here is the Emperor Marcus Aurelius, who ruled from 161 to 180 of the Common Era. And he was a noted student and enthusiast of Greek philosophy. And if there was going to be a Roman emperor who was going to be shown as a philosopher in the Greek-speaking East, it almost certainly would have been Marcus Aurelius. It's interesting. So therein lies the dispute between the museum and Danny. Now, it's obvious to me that neither Turkey nor Danny has presented the museum with direct evidence of the philosopher's excavation in Turkey. I think if there was direct evidence, this would be a different case. However, according to Danny, it does not need direct evidence to prove the archaeological theft of an antiquity. So there was a case in 2021 titled "In the Matter of a Grand Jury Investigation into a Private New York Antiquities Collector." And everyone knows that that antiquities collector is Michael Steinhardt. So in that investigation, the Steinhardt investigation, Danny filed a statement of facts, and it was filed on December 6, 2021, Supreme Court criminal term, New York County. You can take a look at it yourself. I'd like to paraphrase from paragraphs 7 through 12 of the statement of facts. To prove a suspected crime, all investigations and prosecutions may also rely on circumstantial evidence. Indeed, New York State criminal law draws no distinction between the weight of or importance of direct versus circumstantial evidence in proving a crime. The use of circumstantial evidence in proving an antiquity has been looted emerges in ways as varied as the ways in which antiquities are looted. But the most important piece of circumstantial evidence, and certainly the one with which most investigations frequently start, is whether the object has any verifiable prior provenance. The sudden appearance of an unprovenanced antiquity on the international art market, therefore, is often an indication that it has been looted. Standing alone, the absence of provenance does not necessarily mean an antiquity is illegal, but when taken together with other evidence to include, among others, any of the following 9 factors, such evidence is always material, usually probative, and often dispositive. That is especially true when, as here, meaning in the Steinhardt case, many of the seized antiquities presented evidence of multiple factors. So here are the 9 factors of circumstantial evidence that Danny believes is significant to prove an antiquity is stolen. Number 1, the fact that known and convicted traffickers or smugglers were involved in the object. 2, photographs of the object either in situ or with the smugglers or traffickers. 3, the fact that photographs or the object itself show dirt on the object. 4, a known find spot. 5, the fact that the object is an orphan. 6, the fact that there was civil unrest or war in the area where the looting occurred. 7, confirmed and specific looting at the site. 8, the fact that the object was found as part of a group or horde. And 9, false or opaque provenance. Now, the philosopher's provenance is not false or opaque, but it is a little thin. As to the rest of these factors, known and convicted traffickers, well, according to Dr. Marlowe, there were 2 brothers and an antiquities dealer who smuggled excavated and smuggled the objects out of the country. Now, Dr. Marlowe doesn't name names, but if those people are known, then there could be, known and convicted traffickers involved here. We don't know if there are photographs of the object. We do know that, according to Dr. Marlowe, there was a specific find spot where they were found. Was there civil unrest or war in the area? I don't think so, but it was from a confirmed and specific site. It was part of a group of objects that was found. So there are some circumstantial factors here that the museum has to consider. So what is the museum's point here? Well, in the lawsuit, the museum claims that it's entitled to a declaratory judgment that all right, title, and interest in and to the philosopher is vested in the museum, and that Danny has no right, title, or interest in the philosopher. However, it's not clear to me that the district court could grant such a request given the circumstantial evidence against the object. Furthermore, it's doubtful the museum can seek a declaratory judgment without naming Turkey as a defendant here. Remember that the museum is suing Danny. Danny is not claiming to be the owner of the philosopher, nor was Danny acting as Turkey's agent when seeking the search warrant. Danny's obligation under New York law is to investigate and prosecute the criminal possession of stolen property within New York State. And unlike the federal government, New York State has no treaty obligations to investigate the origin of the philosopher or its removal from Turkey. Therefore, the court's declaration that Danny has no right, title, or interest to and in the philosopher in no way impacts Turkey's claim of ownership. Now, the other fact that might not be clear to anyone, but is very clear to me and other lawyers who work on these cases is Turkey could not be subject to the museum's declaratory judgment action because the claim would be barred by the Foreign Sovereign Immunities Act. So my law firm sued Lebanon a few years ago, and we lost that case because it was barred by the Foreign Sovereign Immunities Act. Likewise, around the same time, a few years ago, Sotheby's sued Greece, and then there was a subsequent suit where someone sued Turkey, and all of those cases were barred by the Foreign Sovereign Immunities Act. So in this case, the museum couldn't name Turkey as a defendant. The only defendant it had was Danny. But again, Danny's not claiming to be an owner here. Turkey is. And without Turkey as a defendant, I don't see how a judge could move this case forward. In my view, the proper venue for the museum's argument over ownership of the philosopher and whether Danny has any right to pursue the object is in front of the New York Supreme Court judge who issued the search warrant. Now, it's the case many times that museums are reluctant to go to other states to argue about the ownership of their objects. So in this particular case, I don't think that the museum, Cleveland Museum, wants to go from Ohio to New York to argue in front of a New York State court judge. First of all, the warrant is not enforceable in Ohio without some local law enforcement agency enforcing it. So a New York State warrant would need to be enforced in Ohio through an Ohio prosecutor and an Ohio judge. But that hasn't happened here. So in my view, the museum should be going to the New York State Court judge to argue that Danny doesn't have jurisdiction here. Now, why do I say that? Well, there's a couple of reasons. First, there was a case in 2017 of an object that was allegedly stolen from Iran. And in that case, the judge said that Danny couldn't forfeit the object, which was an ancient wall panel, until a declaratory judgment action that was happening in a Quebec court was finished. So that's probably why the Cleveland Museum sued Danny. It couldn't sue Turkey in this case, but it sued Danny because of this decision by a New York State Court judge in 2017 saying if there's a declaratory judgment action out there, Danny can't act. Now, in that case, the insurer, which was the owner of the object, agreed to voluntarily forfeit the wall panel to Danny. So the case never went anywhere. However, in that case, the judge also ruled that Danny cannot use New York search and seizure laws to forfeit property unless Danny intends in good faith to commence a criminal proceeding against the holder. So it is illegal to possess stolen property in New York. It is a crime to hold it. But remember, the museum purchased the Philosopher in 1986, and the object's been outside of New York ever since. So the museum never was the holder of the object in New York. Likewise, the person who did hold the object in New York in 1986 was Edward Merritt, and he's deceased. The owner of the object before 86 was Lipson, but he was in Boston. So to me, I don't see a holder of the property in New York that criminally possessed it that could be prosecuted here. So my conclusion is Danny has no possible defendant to prosecute in New York relating to the Philosopher's ownership and sale. And therefore, in my view, the museum should be objecting to Danny's forfeiture of the Philosopher in front of the judge who issued the search warrant. But the museum can't do that because it's already waived its jurisdictional objections. I'm going to read now a quote from paragraph 24 of the museum's complaint. The complaint says in paragraph 24, Danny's staff required that the museum agree not to contest a warrant from a state without jurisdiction in exchange for providing information that might persuade the museum that the Philosopher came from Bourbon. To me, this seems like a critical error. First, you never waive jurisdiction. Second, I've never heard of having to waive jurisdiction to get information about the theft of an object. To me, this is critical for two reasons. Number one, if the museum came to New York and went in front of the judge who issued the warrant and objected on jurisdictional grounds, that's not really subjecting the museum to the court's jurisdiction. It's basically saying there is no jurisdiction in the case. So it's not like the museum is voluntarily bringing itself into court and subjecting itself to jurisdiction. Jurisdictional objections don't make you subject to the court's jurisdiction. It's say you're basically coming in and saying this court has no jurisdiction over me. But second, the one thing the federal court in Ohio could do is to enjoin Danny from pursuing the object. So a federal court does have jurisdiction in a dispute between two different entities in different states. So between the museum and Danny, museums in Ohio, Danny's in New York, federal courts can decide disputes between parties in different states. That's why one of the reasons why federal courts are there. And second, a federal court could issue an injunction against an out-of-state law enforcement agency. So it's possible the museum could have sought an injunction against Danny. But again, before it ever went to court, for some reason I can't figure out, the museum gave up its jurisdictional objections. It waived them. So the museum is not able to go into New York State Court and object to jurisdiction because there's no holder in New York that could be prosecuted. And second, it can't seek an injunction in the federal court in Ohio. We'll see where this case goes, and I'll have an update on this case on another podcast as we go along. Thanks for listening.